We're on the subject of liquidated damages, and I guess I should ask the question now. We spent 20 minutes, a half hour, something like that in the planning class, maybe longer, talking about what liquidated damages are. And I realize a lot of people in this class did not take the planning class. So do I need to spend more time in saying what liquidated damages are before I talk about how to apply them and things of that nature?
I think one of the things that came out in the liquidated damage that impressed me is that it cannot be punitive. It is liquidated damages, actual cost of loss. You don't invoke them as a punitive action by law.
Right. Anybody want me to explain liquidated damages?
Usually I think in our Congress we don't really call it liquidated damages, but maybe we just go referring to deductions from the invoice. Is that still considered a form of liquidated damages? Was something totally different?
Liquidated damages is a discrete activity that's identified as liquidated damages. So withholding of invoices is not liquidated damages. And one of the things, I'll just spend a little bit of time, liquidated damages, the reason why, since you're in contract management, since that's the focus of this class, liquidated damages either already have been established or they haven't been established. And so that's why it's not, at this point, typically the situation where you have to worry about, is it there or is it not there? Now we have said a little bit, and we'll say later, you can, through a modification, add liquidated damages even during a contract performance stage. And that's not typically something that would happen, but there can be circumstances. In fact, in a couple slides, we're going to mention one of those circumstances where it might be a good idea. So I'll just mention liquidated, and well, let me go through these, and then after I'm done, we'll see whether you need more understanding of what we're talking about. All right, we've dealt with that slide. So here's the recommendation, saying it much more clearly than I've said before, and emphasize it in big letters and green. Recommendation: if the circumstances exist to trigger liquidated damages, they should be applied. If you have it, do it. If there is doubt whether an excusable exigency caused the lack of performance, the contractor might be given the benefit of the doubt. That's where you might talk with your procurement officer, your assistant AG, about the defensibility. Because if you apply it and the vendor doesn't think it's justified, they can file a claim. So you want to sometimes talk to your AG about, do you think we have a winning case? What do you think is the likelihood they'll file a claim? That type of thing. But if it's clear cut, do it. If there is no doubt, the liquidated damages should be imposed. Another reason has been given to me in the past, that at first I scratch my head and say to myself, what planet are you on, to ask this question, and then I realize no one's ever told anybody what the rules are. That's one of the reasons we're doing this, to tell you what the rules are. So if you don't know what the rules are, then obviously you're not going to know what to do or what not to do. And so this is something I had at a particular time from an agency where they explained that the reason they did not apply liquidated damages is they didn't want to preclude the possibility of going after actual damages. And their logic was what's up here, I guess, in the second bullet. If liquidated damages are applied, the possibility of pursuing this was their logic, of pursuing actual damages is extinguished, but if I don't apply liquidated damages, if I don't seek to collect them, then I still have the option of applying actual damages. And so if it's up to me, the contract manager, and I can either go for liquidated damages or actual damages, which do I think is going to get more money? And if I think actual damages can get me more money, then I'm not going to apply liquidated damages. So that was the logic. And wrong answer. This rationale is erroneous because a liquidated damage provision precludes the ability to collect actual damages. If you have liquidated damages, and this gets to what liquidated damages are, and that is what this slide explains, are a shortcut version of actual damages. That's what liquidated damages are. We're establishing in advance that for each activity that has a liquidated damages associated with it, what the value is for a vendor not performing that activity. So we're saying in advance, here's the target. And in planning, we described how you make that determination, how you value non-performance. And we stressed over and over in the planning class that liquidated damages cannot be penalties. They cannot be something that is designed to simply get the contractor's attention and make non-performance so painful from the standpoint of a monetary standpoint that they will perform simply because they don't want to have the money withheld that we supposedly said would be withheld if they didn't perform. Because the basic contract law is that damages can be collected to the extent damages can be proven, and liquidated damages can be a substitute for actual damages. But penalties are not a provision of contract law. Penalties can only be invoked under torts, under criminal activities, if there's a law that says that there can be penalties, but they cannot be invoked simply because a contract says that we invoked. And if there's ever a question about whether a particular provision, a liquidated damage provision, is actual substitution for damages versus a penalty, if the vendor claims it's a penalty and if the vendor files a claim that's a penalty, and if the Board of Contract Appeals determines it's a penalty, it's unenforceable. So penalties can't be done. Liquidated damages that are properly constructed can be applied and should be applied if the circumstances exist. So the provision is shortcut for actual damages. Theoretically, both parties to the contract have accepted the liquidated damage, the amount of the liquidated damage, as being a reasonable approximation of actual damages. Reasonable approximation. So if there is a liquidated damage provision in a contract, indirectly both parties are agreeing that actual damages will not be pursued. The presence of liquidated damages means you will not go after actual damages for the activities covered by the liquidated damage. If you have something that is outside of what the liquidated damages covers, then you can go after actual damages. But even actual damages is not an easy thing typically to prove. Sometimes it is, sometimes it isn't. And we have examples of both ways. By including the liquidated damage provision in the contract, the state is telling the contractor that the liquidated damage calculation is the extent of damages that can be collected for its non-performance. If it is $500 a day, if you do not have a construction project done, and you do not have it done on the day that it's due, the damage is $500. It doesn't matter if 10,000 people are inconvenienced because they can't go on that road that day, and the value to those 10,000 people is $100,000. If we said the liquidated damage is $500, that's all you can collect if the vendor didn't complete the construction on that day. $500. You can't go and try to prove 500 is too little because you said it was 500 and the vendor priced out their contract that if they don't perform, they're going to pay $500, nothing more than 500. So it's applied against us as well as for us. Contracts go both ways. If it is desired to afford more leniency or flexibility in the imposition of liquidated damages, then only in instances of exogenous circumstances, i.e., if we really don't want to nail the vendor each and every time something isn't done, we can write into the liquidated damages the value, and then we can put caps. We can say that even though we're going to charge you $500 a day, we will not charge you more than $5,000 for non-completion. So the vendor knows that in no circumstance will they ever pay more than $5,000, even if they have 20 days times $500, because we've put a cap. Now, in planning, you have to make decisions about what is the value, and should you do things like this? Should you put caps in? And the first reaction might be, why would you ever do that? Because if there's a value, and if the vendor isn't performing, why don't we collect from them each and every time they don't perform? And typically that's what you want to do. But if you have a circumstance where there's a lot of risk involved, so that the potential to pay a lot of liquidated damages may scare off vendors altogether, or may make them inflate their prices to such a degree that you can't afford them, that might be a reason. Now, I'm not saying that happens typically, but that's the kind of thing of why you might not. Constructing specifications, you have to have a lot of crystal balls. You have to do a lot of projecting, and a lot of anticipating, and a lot of calculating, and a lot of guessing sometimes. What should you do and what shouldn't you do? What's going to get bids and what's not going to cause vendors not to bid? What's going to get good bids, good prices? What's going to cause it to go into the stratosphere? And you have to make your best calculation and your best projection, and you have to make adjustments based upon your feedback from your vendors. If you have unlimited liquidated damages each and every instance for X amount of money, and you have vendors that are sending you questions and are at the pre-bid conference are going to say, will you cap this? We can't bid unless you cap this. I'm telling you right now, unless you put some limit in here, we're going to walk away from this. If you're hearing that from your vendors and you have the credibility, you believe them, it may be in your best interest to put some caps in. If you don't hear that kind of hue and cry, then don't cap it. But what we're saying is that you have the ability to construct many things in the specifications, what is there and what is not there. And in contract management, you can only invoke what is already there, either initially or that is added through a modification. If it's not there, you can't do it. And so we're saying that if you had the provision that, number one, since there's a mandatory clause about the excusable delays, you're going to have that. If it is desired to have anything beyond that, that would be a limitation. It has to be in your specifications to begin with. And again, that would be additional circumstances when damages may be waived, should be included to begin with in the solicitation contract, not just the right to waive applying damages, because you're not going to say you have the right to waive damages aside from excusable delays. But if you have, you might have specific additional circumstances when damages might be waived, or a maximum liquid damage amount, regardless of how many occasions there are that otherwise would trigger liquidated damages. If it's an let's say you have a data system where you will, for every minute the system is down, you might say that it is $100 of liquidated damages because there's the whole department, let's say, cannot use that system if it's down. For every minute that it's down, people who wanted to go and use this to do work can't do it. And so there would be a calculation of how many people would use the system and what their value is for each minute that they can't use the system, etc. And you might come up with $100 a minute. So theoretically, if it's down for the whole day, that's 24 times 60 times 100, which is a lot of money, I guess. I can't do the calculations that fast, but you're into the thousands of dollars. Is a vendor willing to sign on to maintain a system if they might be charged $5,000 or $10,000 a day if it's not working? And it depends. So sometimes you'll put a cap that says we'll charge $100 a minute, not to exceed $1,000 a day. So that no matter how much it's down, they know $1,000 is the maximum exposure. If you feel that's prudent, you put it in your specifications, then you don't have to apply it. You wouldn't apply it if that's in your specs if a system is down the whole day. It's just $1,000 and that's it. So a lot of what you plan and what you write to begin with, and then what you implement when it's at the point of performance. Unless there's an ambiguity problem as per slide 237, which that was one of the slides that was deleted, so you won't read about that ambiguity problem in the slide that isn't there now. A contract should not be modified to delete a liquid damage provision. And that's something. You would not do a modification to take away an existing provision without some additional compensation to the state, because doing that will make the terms of the contract more lenient to a vendor. If without changing anything else, you simply do a modification, let's say the vendor comes to you and says, well, gee, you're really docking me for liquidated damages all the time. We weren't expecting to have to forego this much money in liquidated damages. Can you cut me a break, and can we do a modification that reduces the amount of liquidated damages? And because you want to be a nice person, you say, okay, we'll do that. We'll reduce it by a certain amount, etc. We did talk on last Monday about Article 3, Section 35 of the Maryland Constitution, that in so many words says you cannot do that. You cannot allow a vendor to get more benefit under a contract after it is awarded than they would have gotten before it's awarded. In other words, you can't change a contract to have a vendor make more money without more deliverables. So if you're thinking about doing a modification to eliminate liquidated damages and nothing is changed either in terms of what the vendor is paid, i.e. a reduction in what they're paid, or nothing is done that would be increase something commensurate with the reduction, you are prohibited by the Maryland Constitution from doing that. So I don't know if you would be tempted to do that, but we're telling you now, don't do that. Because unless the contractor provides more services without more payment, or offers some type of price cut to continue to provide services without any other reduction, then you can't do that. So if it's in there to begin with, the circumstances is clear that you should apply it, you should apply it. If it's painful to the vendor, hopefully they will do what they need to do to avoid the pain. Do the performance. Now here's where it might be a situation that you might add liquidated damages after a contract has gone into effect. One of the possible circumstances. Excuse me. We will talk later in the class about novations. Novations happens because vendors merge, one vendor purchases another vendor, things of this nature. A vendor spins off a subsidiary and wants a contract transferred to the subsidiary rather than itself. These are things which are called novations, basically changing the contractor. And as we will talk later in the class, that vendors cannot do this without our permission. They cannot simply have a state contract sold to somebody, given to somebody, transferred to somebody without our approval, because our contracts say they can't do that. And so since we have to give the approval, basically what we ask ourselves is what's in it for us in approving a vendor to transfer a contract or something of that nature. And I realize, as we say in the class and the slides on novation, sometimes we don't have a whole lot of leverage. Sometimes the vendor comes to us after they have been bought, or after they have merged, or after they have spun off, and say, here, pay the bill to somebody else. And that's the first time we know that it happened. And what we're going to tell you is, no, you will not pay the bill to somebody else until you do a contract modification to change who the vendor is. And you shouldn't do a contract modification unless you are sure or have reasonable assurance that the vendor isn't going to lose out by doing this transfer, etc. And this is one of the things that you might do to help avoid the state being in a less good position by transferring a contract. For instance, we might say to a vendor, before we agree to a novation that allows you to transfer this contract to a subsidiary, we now want to establish liquidated damages, or we want to increase the amount of liquidated damages, or we may want to invoke insurance, add insurance requirements or bonding requirements, things of this nature, so there's more protection for the state. So that could be a possibility where you might change something to increase it when a contract is in effect. So it may be advisable to require the addition of liquidated damages to a contract, to a specific aspect of a contract, if you have that type of circumstance, or to increase liquidated damage amounts, or additional circumstances when they apply. And again, you always have to be conscious that you're not doing it as a penalty, that there is some additional cost aspect to you that you have to cover yourself if that happens, and that's why you're increasing it. Before agreeing to a novation or an option, but doing this for an option renewal requires a simultaneous modification. Sometimes we discuss renewal options later on. You may want these things before you agree to a renewal. And if you do, you have to do a contract modification. A novation, as I already said, already requires a contract modification since the contractor is changing. So this is another possibility involving liquidated damages. Now here's something that first came up to me, the first time it was ever raised to me was about March of this year, February or March, and the agency submitted specifications that I was reviewing, and they had a whole series of liquidated damages. And for the first time, the agency was establishing a number of liquidated damages for what are startup activities for the vendor under this particular contract. That the contract was supposed to start, let's say, July 1st. But they had a series of time frames that said the vendor shall do something by April 1st, something by May 1st, something by June 1st, even though the contract didn't officially start till July 1st, and even though they didn't start getting a penny until after July 1st, the agency was establishing liquidated damages for the vendor not doing things of startup activities. And as I said, it was the first time I'd ever seen an agency try to do this. And so the first thing I thought to myself, does this make sense? And I had two reactions, yes and no. Take your pick. Well, I had two reactions, yes and no, and didn't say take your pick. What I said is, okay, to the agency, if you can explain to me how each of these liquidated damages amounts are reasonable based upon additional cost you, the agency, will incur, then I will be okay with you establishing liquidated damages, because that's the essence of liquidated damages. You have to be able to say how you got to whatever amount you say is the liquidated damage amount. You have to be able to calculate it, and it has to be reasonable compared to the harm that is done if there is non-performance. And so I said to the agency, tell me how you came about this. And we had a series of back and forth emails and phone calls, and even one face-to-face meeting. And bottom line is they couldn't explain to me how they got to any of these numbers. And the first reaction I had is, if you can't explain it, you can't do it. Because if you can't tell me how you came to an amount being a reasonable approximation of damages, then how am I to be convinced that you have any damages whatsoever? So if a vendor did not rent space by April 1st for a contract that starts July 1st, what is the harm to the agency that the vendor did not have the space rented by April 1st? Now, obviously, if it comes July 1st and they don't have the space, which means they can't perform the contract, a whole lot of damages will come into effect. But what are the damages because they didn't do it on April 1st?
Well, I mean, they could have been, you know, scheduling moving, and they needed that space by a certain time because moving people, you know.
You're talking about the agency might have had
I mean,
space issues?
You might have reasons to do that ahead of time because let's say you're building a building for employees. You've got to move the employees from their old building, so you've got to schedule the move. You've got to put the furniture somewhere. I mean, it kind of makes sense.
Well, what you're saying is what I was expecting to hear. If you can explain what the harm is going to be and what additional expense is going to be incurred, if you have people that are ready to do something and can't do it, that is a damage. if, because a vendor doesn't have space on April 1st, you as the contract manager are going to step up your activities to monitor. You're going to start holding more frequent meetings and things of that nature. You can have damages because there's an expense because they didn't meet a time frame. But there were, the issues were they had to be able to explain it. And then the other issue is, how are you going to get these liquidated damages when the contract hasn't started and we haven't paid them any money yet? So if there even was a reasonable aspect to liquidated damages, they only could be applied, presumably, after the contract started. Because until then, we haven't paid the vendor any money, so we would have to bill them affirmatively, which maybe they would or wouldn't pay. And the other issue was, well, what if they didn't meet the time frame by April 1st, but they were ready to go by July 1, everything was in place, did we have an expense? And so came down to, theoretically, and this is the only time I've ever had this, and I talked to my attorney, and we agreed that potentially the concept made sense if they could explain how they could establish the damages, and then would go beyond that and explain when the damages would be applied. And in this instance, they couldn't even go to first base. They couldn't even explain how they even had damages. And so they just took the whole thing out. So, and I will address your point within a slide or so. Let's see. It is potentially possible to establish liquidated damages applying if a contractor does not perform startup aspects of a new contract in a timely manner, if the contract allows startup payments, if they allow startup payments. Sometimes we do have payment up front for startup. If we have startup, obviously we can apply damages against the startup payments if we have that, but most contracts don't. If you have it, fine. If not, then you can't do that. If the contract does not allow startup payments, the liquidated damages can only be assessed against payments once the contract begins. The circumstances when not meeting pre-contract timeframes might legitimately merit the establishment of liquidated damages, would be when the vendor's lack of progress towards being ready to properly start the contract on time causes the agency to incur expenses to prepare contingency plans, obtain backup contractors, increase monitoring activities, etc. And that's what I was looking. Can you tell me what you're going to do if they don't meet these time frames? And when they couldn't tell me a thing, I said, then you can't do it. And I told them. And I even gave them suggestions. Are you going to increase monitoring? Are you going to make preparations? Are you going to get things as fallback positions? No. Well, if you're not going to do that, you can't have liquidated damages, because if you don't have an expense that these damages are designed to protect you against, then they're penalties, and you can't have penalties. So it all gets down to the same thing. Either damages or penalties. You can have damages, you can't have penalties. Depending on the circumstances and liquidated damage contract provisions, the liquidated damages might not apply if the contractor, and they're still on the subject of startup activities, if the contractor actually started the contract properly and on time. As I said, if you had various time frames before July 1st, they didn't meet them, but July 1st, everything was in place, did you have damages? And that depends on what you had to do to try to help spur the vendor to meet the July 1st deadline. So if they started on time despite not meeting a preliminary time frame that was intended to provide insurance that the contract would be timely and properly started. So might not apply if they start on time. In other words, if the reason for the preliminary deliverable was to provide confidence that the contract would start properly, and it did start properly despite the deliverable not being met, perhaps there would be no reason to invoke the liquidated damage, because we had no damage, unless we had the incurred contingency expenses. So some additional thoughts. All right. Now that I've explained more about liquidated damages, does anyone want me to go further? Okay, Gary said no, you don't. But you say yes, you do. Go ahead.
If part of a contract is, I mean, the contractor is performing their primary function, but one of the provisions in the contract is for them to, say, provide a monthly report.
Yeah.
Okay. if they're consistently late with the report, okay, and once the state receives the report, then state staff take that information and then perform work and possibly collect monies. I mean, couldn't that be developed into some sort of liquidated damages?
Yes. And when you said primary activity, and it sounds like the report is more than just a casual circumstance. It's something that is very necessary from what you said for other things to happen. So the lack of a report being on a timely basis causes problems for the state personnel.
Right, because they need to receive the report and then take some action on the information in the report.
So the question, basically her question is, I guess, can you have liquidated damages for the failure of a vendor to do a report on a timely basis?
Yes.
The answer is yes, you can, if there's going to be a cost aspect to the vendor not providing it on that time. Something I said in planning when we went over the issue of meetings, reports, things of that nature, one of the things I say to agencies when I'm reading specifications and they have meetings and reports, I say, particularly with reports, I say, okay, who gets it and what do they do with it? And if the answer is scratching of the head and saying, well, gee, I don't know who gets it, and oh, I don't know that anyone's ever done anything with it, then my first answer is you probably shouldn't have a report. But if that's the situation, should there be liquidated damages? Probably no, or if there are, very, very minimal liquidated damages if it goes maybe a week beyond something like that. If it's a different situation, that a report is critical to action being taken, that if it isn't done by the day specified, there's going to be an immediate going back to the vendor and saying, I need this. And there's going to be other activities that the state would be doing to bill or to get money from the feds or something like that, or to serve clients that can't happen. The value of all those things, that either the cost of your time, if you even call them up and you get paid when your time is worth more than what you actually see in your paycheck. I know that one is inadequate, but the value to the state of your time is both what you're paid plus all the fringe benefits, indirect costs, the cost of your space and your telephone, everything out like that. And so if you get paid $30 an hour, the value to the state of you might be $60 an hour. And if you make a phone call that's 10 minutes in duration and you get, your value is $60 an hour, then that's 1/6 of 60, that's $10 just for making a phone call. So you can have, and that's how you get to liquidated damages. That you can just, and you don't have to prove that every phone call costs $10, but you have some approximation of how you can reasonably get to a number. And it's like, if the first day I don't have it by the end of the day, I'm going to be on the phone with you, and it's going to be 10 minutes, $10. And the second day, it's, I'm going to be on the phone with you, plus an email, plus now we have 2 people that are sitting there that can't do their work because they don't have this input. The value of those 2 people for however long they can't do their work is $60 an hour. So that's how you get to liquidated damages. That's how you calculate what the value is of the vendor not doing it. And if that's something, a report is critical, then you use that whole thought process for what are the liquidated damages.
Because we tried to do a mod and add liquidated damages recently, and we weren't able to do it. But
because the vendor didn't want to agree to it? When you say weren't able to do it, what do you mean?
no, from the state, from the people that were reviewing it.
Internally?
Yeah, wouldn't let us do it. But maybe that's because I guess the damages may have been perceived as arbitrary.
Well, if they're arbitrary, that means they're a penalty and you can't do it. That's right. So, but that comes down to how well can you express the harm from a vendor not performing. And if you can't express it, save your breath.
Well, also remember that you can still have damages. You can still file a claim against the vendor. The liquidated damages really simplifies the process, but as Joel said earlier, doesn't necessarily reflect the actual cost. So when you get into a contract and you're really operating it, and then there's a breach, or there's something happening where damages might be appropriate, you may be in a better position to analyze what the cost of those damages are and make an argument for a claim, right?
Yeah. I mean, if you don't have damages, you can pursue, if you don't have liquidated damages, you can pursue actual damages. But the one is usually a whole lot cheaper and easier to implement than the other. Liquidated damage, here's the definition of what triggers the damages, here's the amount, you didn't do it, here's what I deduct from you. Actual damages, you have to prove it, you have to calculate it, you have to file a claim, that type of thing. It's a whole lot more complicated, yes.
So if she can't do the liquidated damages, she could then withhold money from paying?
She can withhold money if she thought there was actual harm. And she can withhold money supposedly commensurate with the harm that is done, because she's basically saying that she had damages. And so that gets down to, why was she told she couldn't do it? Because there's no prohibition against an agency seeking to add liquidated damages after a contract's in effect. But you have two issues. Number one, you still have the issue of, are there damages? Can you identify them? Can you calculate them? And then if it's after the fact, you have to go to the vendor and basically, hat in hand, say, please, vendor, agree to these damages if you don't perform. And from a vendor standpoint, why would they do that? So I'm not saying you can't get it, but usually there has to be something else going on before we have the leverage that can make a vendor agree to liquidated damages. And usually that leverage is going to be actual damages, or that you're going to terminate or something like that, or you're not going to exercise a renewal option. That's when you might do those things and actually have some credibility, where the vendor will agree that's the lesser of the evil than not have the contract renewed or being terminated. But if you could go to the people internally and make the case for the damages, if they were reasonable, there's no reason why they should have told you you couldn't do it. Getting the vendor to agree is going to be another problem. All right, who decides what? Who decides what? You asked.
What agency?
The contract manager can decide whether to apply liquidated damages, since virtually all pertinent circumstances are already defined. What the performance requirements are and what the damages are. The only decision to make is whether an instance of non-performance is excusable as being beyond the control of the vendor. So I'm the contract manager. I know what is to be performed. I know whether the vendor performed it. I know what the amount of liquidated damages is. And so now the only thing I have to find out is, why didn't the vendor do it? Well, they didn't do it because they didn't do it because they didn't do it. And gee, our people didn't come to work, and we had turnover, and oh, we had other priorities, and gee, our contract manager just forgot that was supposed to be due. Oh, okay, fine. The good excuse is we won't apply liquidated damages, right? Hopefully you're saying no. Those are not good excuses. Those are not excusable delays. The fact the vendor had turnover, unless there were no people out there to hire possibly, but their problems internally are not your problems. That's not an excusable delay. So other than that, you invoke the damages if they're there. But all right, now we go to the other thing. In yellow, only the procurement officer can make decisions concerning actual damages. Here's where the procurement officer comes in. Liquidated damages, contract manager, because it's been defined. Actual damages, a whole nother story. You need to get the procurement officer involved. Also, the procurement officer will make liquidated damage decisions if a claim is filed by a vendor about the imposition of liquidated damages. If you, the contract manager, invoke it, and then the vendor says, this really is a penalty, instead of being liquidated damages, I'm filing a claim that the agency improperly deducted this money, the procurement officer is the one who answers claims. So
Is this slide approved by the AAG?
this slide has been approved by our Assistant Attorney General, yes. The slides that appear have been approved by the Assistant AG. At least the one who was reviewing them, which means the next Assistant AG may not agree with it because there's lots of disagreement among the attorneys. But hopefully, most of them will agree with this. At least this is what the story, this is the DBM position and we're sticking to it. So if you're dealing with us, this is what we're going to tell you. All right. Now that, for the most part, is all we're going to say on liquidated damages. Anybody have any questions? And Gary's there. Come on, let's get on with it. Move on. Okay, moving on. Withholding of payment. We have said we have contractually provided remedies, liquidated damages being one, withholding being another, two forms. We're going to deal with the first, routine, and that's simply you get a bill, should you pay the bill? Should you authorize it for payment? State contracts should have wording that allows withholding of payments of a contractor invoice if the goods or services for which payment is sought were not satisfactory in terms of quantity, quality, or timeliness. There is no mandatory clause that says you must have this in there. And even without a clause, which is what it says at the bottom there, even without such a clause, the appropriateness of paying an invoice needs to be verified before it is approved for payment. I mean, that is implicit in contract law that you only pay for what you get that is compliant with the contract. But we suggest you have this general clause anyway, and I think it's in virtually every agency's contract I've seen. It just says we reserve the right to withhold payment if contractor has not met the requirements of the contract, and it's only like 2 lines or something like that. The objective of withholding payment is to take advantage of vendors' desire to collect payment for their activities and from their perspective to get the money as soon as possible. Vendors want paid. Pay me now. Pay me before I do anything. Pay me more than I have asked you for. Pay me, pay me, pay me. That's what I want. That's the profit motive. And vendors want to get money. So since their desire is to get money, if we hold up the payment of money, it is a disincentive to them because they want money. So vendors are motivated to resolve issues when those issues result in delays in getting paid. Well, before I pay you, you have to give me my report. You have to do this. You have to do that. All right. Well, then that is a strong motivation to the vendor complying so they get paid what they think they're entitled to be paid. Plus, showing the contractor that agency personnel are checking invoices. That sends a very strong message that someone is actually looking and actually deciding whether it's appropriate to pay. That's something that doesn't happen all too frequently, that no one does the checking, and if the vendor simply gets paid whatever they invoice, regardless of what they do, that sends a very powerful message that you don't want delivered, but it's being delivered anyway. Doesn't matter what you do, just send in the invoice, you'll get paid. Not a good prospect from the state. So let's see. So again, showing the contractor that agency personnel are checking invoices and verifying that deliverables have been satisfactorily provided before approving invoices reinforces that the contractor has to properly perform to be paid. That's what we should be doing. Conversely, if a contractor bills for goods or services or deliverables before it should, it's not supposed to bill until a certain thing happens, but it sends in the bill prematurely and the bill gets paid. Sends a bad message. Or if it's paid for subpar performance, the message that it received is that no one is checking the contract or what the contractor is providing, so the contractor is encouraged to perhaps skimp on performance and hope it gets paid anyway. It's, well, I got away with it, what else can I get away with it? So, because we are telling you these are the things you should do, this is what we are suggesting that you should do routinely. Before approving an invoice, if you are the one whose job is to approve the invoice, or if you're the one who is writing internal agency procedures for payment of invoices, or if you are writing things in specifications as to who will receive payment and what the timeframes are, these are things that you should be anticipating, and these are things that you should make sure the people within your agency who authorize invoices are aware of and hopefully are following. Number one, as we said last Monday, the first thing you always want to make sure is there is a contract. That you get an invoice, there's a contract that that invoice is being issued under. So whether it's a purchase order, whether it's a formal contract, whatever it is, a contract exists. This may seem a little strange, but the contract is with the invoicing vendor. Well, if sometimes, as I mentioned before, this is how you find out the vendor has been sold. Because you get an invoice that instead of being for ABC company, it's for DEF company. And wait a minute, we don't have a contract with DEF. We have a contract with ABC. So you go back to ABC and say, why are we getting this invoice from DEF? Well, we just been bought by them. Well, we didn't know that. We haven't approved that. You will not authorize the payment. You should not authorize the payment. You should immediately say to the vendor, you need to come in with all the circumstances, the legal papers that indicate the purchase, the assurances that the new vendor is going to meet the terms and conditions of the contract. Everything's going to be the same from the state perspective. We haven't lost any leverage, all of that before you approve an invoice. So you should make sure you have a contract, it's with the vendor who is doing the billing. Now, an exception to that is this one, and this is right in 21050224A, and most people don't know that is in there. Vendors do not need our approval to assign payments. For instance, if they got financing from a bank, they could send in, they have to notify the agency that the payment is to go to somebody else. But they don't need our approval because it's in 21050224A that says right there they can do it if they notify us of who payments are to go to, so that we have a formal notification from the vendor that payments are to be made to their bank, etc., or whoever their creditor is, and then we will make payments to that entity even though the contract is still with our contractor. So other than that, they can't transfer. They need a modification if they're going to transfer it. If they want to make payments to somebody else, we can do that if they notify us. Yes?
What if they have transferred and they're just notifying us that the company that borrows where the paycheck should go? What's the difference?
You won't pay the money. Until there is a formal contract modification, you will not authorize payment.
But you say right there that if the contractor notifies us that they want
assign contract payments. That's just the assignment of payments. That is not changing who the contract is not with. It is not changing who is responsible to do anything. It's just instead of paying ABC, you pay M&T Bank. And so the invoice will come in from ABC, but the payment will go to M&T because you have something in writing from the vendor, someone in a position of authority from the vendor that says we have obtained financing from M&T, we have put up our receivables as collateral for that, so we are asking you to make all payments to M&T. And in that case, you can pay M&T, but the invoice is still going to come from ABC.
Right, but you can't send it to another contractor.
And if they did not give you this notice, you don't do anything until you get the notice for payments. And if they have switched contractors, then there's more issues. Excuse me. Let's see. Still on the issues of what you should verify before you approve an invoice. The date when the activity, the good or service, was provided is within the term of the contract. One of the things you cannot do is that if a contract starts on July 1 and the vendor is only supposedly doing deliverables after July 1 and is entitled to payment for deliverables after July 1, there can't be an invoice for services provided on June 1st. There was no contract in effect on June 1st. There was nothing they were entitled to payment for on June 1st. So you need to make sure that even if it's from the contractor, that it's for activity that happened within the term of the contract. It wasn't before and it wasn't after, unless you have a run-out provision that specifically says there will be payment after most of the contract is over. So you're looking at that. Is it a billing period does not precede when the contract starts or occur after the contract ends? And actually, this is one of the ways we at DBM look for to identify whether you have retroactive contracts. If the contract says it starts July 1st, but the vendor is paid as of June 1st, when did the contract actually start? And maybe the contract started May 1st in actuality, and because you don't want to say it's retroactive, you just say it's June 1st, even though the vendor was told to go ahead and start on May 1st and is doing work and feels they're entitled to payment. And then we're going to have another situation. We're going to have a voidable contract that has to be approved by the Board of Public Works if that's what we determine is the situation. So you need to make sure that we have the proper time frame. Making the payment will not cause the maximum contract amount to be exceeded. Typically, most contracts will have a not to exceed amount in them. And if they don't, then there's something that gives a maximum amount to be paid. For instance, ad picks. There's a limitation in ad picks of the payment. So if there's a maximum amount of payment, and when you get an invoice and someone does the checking and they find out if paying that invoice causes the not to exceed amount to be exceeded, you can't pay it. You have to go back and get some kind of additional approval before you can pay that invoice. And that additional approval is either to change a not to exceed amount, depending on the circumstance, excuse me, or it may mean going to the Board of Public Works for approval to retroactively increase the not to exceed amount, which is a nasty situation. So try to make sure things are done ahead of time. But the other thing is, don't pay for things the vendor is not entitled to get. Don't pay more than the contract says unless there's some kind of a modification to change what the payment should be. And whatever modification there is has to have the necessary approvals for that change. Make sure the activity being billed, you, the person who was approving the invoice, is within the scope of the contract, is not included in another deliverable that has a separate billing amount. And this occurs. If you're not paying attention, you'll get a bill for activity A. And if you really are not familiar, you may not realize that activity A is part of another activity that the vendor either has already charged for or still could charge separately for, that there's not an agreed upon amount for activity A by itself. That should be something you examine, that you're not paying a vendor twice, not paying them for things they're not entitled to payment for, even if it's within the overall amount of the contract. You don't approve payment for things that the vendor's not entitled to. It's for the correct amount. That's elementary. Correct amount either in total, meaning the math is right, things of that nature. Unit pricing is correct. These are things you should be looking for. And another one, has not already been billed. And that may seem simplistic, but in particular, if you have the same amount billed month after month, if you don't do what might be on the next slide or one of the next slides, and if you're not keeping close tabs on payments, you may look and see, all right, for the month of May, the payment is $2,000. For the month of June, the payment is $2,000. For the month of July, it's $2,000. So you get an invoice for the month of July for $2,000, and let's say you get that in September, and maybe someone didn't realize that you got the same invoice in August for July for $2,000 and has already been paid, because there's nothing apparent about the invoices that makes you know there's a duplicate invoice. So that's something that you should be paying attention to. And what we say here is to avoid that, in your specifications, tell the vendors to have a unique invoice number on every invoice. So that even if it is recurring, same amount every month, you can tell just by looking at the invoice number, you know if you've paid invoice 1,280, and so if you see 1,280 being paid for 2,000, and you get another one for the same month on a different invoice number, you can trace down that you've already paid for the month of July on a different invoice number. So this is one actually that the legislative auditors recommend all the time. And it's something that hopefully you will put in your specifications, so you tell vendors they're supposed to do that. But if you miss that in your specification, in your work initiation conference, this is still something that you can bring up to the vendors. We would like you to bill your invoices with unique invoice numbers. Now, you cannot require it as a contractual commitment if it's not in the contract, but you can still ask them to do it. It's always best to put it up front in the contract, then you can require them. Let's see. So that's the duplicate payment, avoid duplicate payment. So that's what all that says. Let's see. Before approving an invoice, verify the activity was actually performed or received. So we know what they're supposed to do, the time frame, the amount, all that's correct. Now we get to, did they do it? The quantity being billed is the quantity received. All activities were the required quality and within the required time frame. For activities requiring acceptance testing, that the testing was performed and validated that the criteria for acceptance was met. The arithmetic is correct. Addition, multiplication, subtraction, the whole bit, everything is correct. For long-term contracts, these are existing suggestions. Periodically, it might be verified that the contractor is still in good standing with the Department of Assessments and Taxation, Department of Labor Licensing and Regulation, the Controller's Office. There is a mandatory there is the inability to talk on a long-term basis. There's a mandatory clause that says the vendor agrees that they will remain in good standing. They have paid all taxes, things of that nature. So one of the things that you might have in your contract management plan is that on the anniversary date of a multi-year contract, you might go back to these entities and re-verify that the vendor is still in good standing. Because very frequently, vendors miss things. And they don't pay their taxes, or they don't renew their corporate charters and things of that nature, which means they are not compliant with the contract, not an actual deliverable, but one of these intangible type deliverables. And the ramification is that if there's a problem with the vendor and there has to be, let's say, a lawsuit filed, if they forfeited their charter, are they still a legal entity? Can we still go after them? So one of the things that was said, I think last Monday, was one of the terminologies was that boilerplate is unnecessary verbiage until it isn't. All this stuff means nothing until you actually have a situation where you need to invoke it, and then it better be there, because if it isn't there, then you don't have the ability to do something that there should be the ability to do. So your contract compliance checklist should have a reminder, a tickler, to do this periodically throughout the contract. Now, for me to stop talking a little bit and give you a little break from me talking a little bit, I'm going to go back to a situation which happened to me many, many years ago and involved invoices and checking. So in this particular situation, and actually it involved the Eastern Shore Hospital Center for a pest control contract. And when the first bill for pest control came in from the vendor, it was received at Eastern Shore, and the contract manager looked at it and said, wait a minute, the invoice is for twice the amount of money it should be. And so the contract manager called the contractor and said, you billed the wrong amount. you need to send me a different bill for the correct amount of money. And the contractor says, well, let me check, I need to get back to you, and called them back like within an hour or so and said, oh no, it's not wrong. Let me tell you what happened. And it was a 2-year contract for pest control that asked for a flat amount of money for the 2-year period, and that billing would be done on a monthly basis. And so logically, if you have 2 years, that's 24 months, and if you bill monthly and you have a fixed price, you divide 24 into the fixed price, and you bill the amount 1/24 each month. And the vendor called back the contract manager and said, we're bad. We thought it was a 12-month contract, and so actually our price is only for 12 months, so this is the correct bill. It is 1/12 of our price. So please pay us the amount of money. And that explanation makes it all right, right? No. No? What should be done? What's the problem?
Didn't they have a pre-bid to talk about this?
Hopefully they did, and whether they talked about it or didn't talk about it, this happened. So it shows you how things can happen that seem ridiculous, because how many people would think, how many vendors would say, I didn't know how long the contract was, so I didn't know I was bidding on a 2-year contract. Pay me my money. Yes?
Was the bid page clear? The bid page must have been clear. It was a fixed amount times 12 months.
Bid page had a line for an amount, for a flat amount. And in this instance, the bid page did not have 12, 24 months, whatever. It just had one amount, and you had to go back to the specifications to see the duration on the contract. So there was a disconnect, if you want to call it that, between what was on the bid page versus what was in the specification part. And the vendor, who was the owner of the company, said, and this is what this person told the contract manager, when my people came to me and asked me for a price, they didn't tell me this was a 2-year contract. They just said, they showed me this bid page and wanted me to fill in a price, and since I'm accustomed to 1-year contracts, I just assumed it was a 1-year price. I didn't go look at any of that other stuff in any other pages. So, do you pay the vendor what they billed? No. How many think you don't pay? All right, what do you think you should pay them? 1/24? All right, let's see if our studio audience from a previous session, what they said. Answer for now, bid prices cannot be changed after an award. The contractor was told it must perform the contract for this price. The agency would not, and legally could not, pay the higher amount. The vendor would not have won the contract at the higher amount. They would have been bidding twice the amount. They never would have won. That not performing the contract for this price would be considered defaulting on the contract and could indicate it was a non-responsible vendor for future procurements. Let's see. And going back on this, basically, and if you get down to, was there a mistake? And the only way a vendor could have conceivably have gotten any relief from performance as if there was a mistake, and for a mistake to exist, it has to be obvious that there is a mistake and obvious what the intended price is. There is no way that a vendor telling you that they didn't know it was a 2-year contract is an obvious mistake that the state could give any relief on. And when I say relief, the only relief you can give is to let them withdraw from the contract. You cannot change the price. So in that situation, they were told, perform or else. And I believe that that vendor did perform. They grumbled, but they performed for that price. All right, answer for the future, and this is where you were going. The bid sheet should not have had only a single amount to perform the contract. It should have had a monthly unit price times 24 to get to the 2-year total. So everyone knows that it's not the end price divided by 24, it is the monthly price multiplied by 24 to get to the end price. the agency should have at least made a telephone call to the contractor as a sort of work initiation conference, as we discussed last Monday, to go over all major aspects of the contract, including price, meaning the situation could have been discovered earlier. Not that that would have made a difference, it just means they would have discovered it before the bill came in. But even if the alleged mistake had been discovered earlier, as long as the discovery occurred after the award, and that's the key, after the award, had been made, the result is the same. The vendor has to perform for the bid price. If it doesn't, it will be subject to being declared non-responsible for future procurements, whatever remedies that we have for vendor non-performance. So you all get gold stars for that one. Caveat. Now we go into the complications, the other side of the story. Okay, I'm the vendor. You're threatening me. You're threatening me with, you're going to tell everyone else in the state, and I'll never get another state contract if I don't perform. But I was expecting to make twice as much money. So what am I going to do now in performing? So since it has now been learned that the vendor apparently intended a much higher bid price, even if it acquiesces and performs the contract, it may try to skimp on performance. This is one where you might say to yourself, okay, I really need to be very attentive to the contractor's performance on this contract because I know they wanted twice as much money. Now that I understand they claim they made a mistake, I may have issues, so I need to be doubly vigilant. Diligent? Vigilant, that's the word. It's one of those words.
In your case, I can't see how it would not have affected their performance.
Yeah, I mean, but still, you have the right to hold them to performance. So the agency should be prepared to monitor the contract closely and immediately note any subpar performance and require the prompt remedy of deficiencies. Alternative answer for the future. If this situation had been discovered before an award, and that's where you would always prefer that you discover it, sooner rather than later. The vendor might have been permitted to withdraw its bid. Now, again, you're into iffy situations. Is it obvious a mistake was made? Well, on the one hand, you can say, no, it's not obvious that the vendor misread 1 year for 2 years, or 2 years for 1 year, etc. On the other hand, sometimes you have practicality and reasonableness that comes into play. In this instance, it was well known that this particular vendor always was a high bidder and never won. It had never won a contract before. It bid every time, but always was higher than anybody else. Not that its price, at half the price, was basically in line with what other people typically bid to begin with. But this vendor in this instance was always high and never won. So this time, the agency was surprised with the result. And what they thought to themselves was they finally gotten the message. They finally gotten the message that if they really want to win a contract, they can't continue to bid that high price they've always done. So I guess they've decided to get with it, bid a reasonable price, and lo and behold, they won. So their strategy paid off. That's what the agency assumed happened in this situation. But they found out that that wasn't right. But if the vendor told the agency before an awards, now we're going to all the permutations that could have happened. So if we were even before the award, if the vendor had, if let's say the agency went back to the vendor and asked them to confirm their price, or in discussion before award to verify the accuracy, they had learned that the vendor supposedly had this differing interpretation. If the vendor would have told the agency before an award that it misunderstood the term of the contract, had intended to bid higher with Assistant AG approval, because you always have to involve your Assistant Attorney General when there's an allegation of mistake in a bid price. The agency could have agreed that a mistake had been made and allowed the vendor to withdraw its bid. And that is the only option if there's a mistake, but the intended price is not obvious. The only thing they're allowed to do is withdraw their bid price. Withdraw their bid, period. Yes?
So you're saying at the time of bid opening, and say the vendors were there at the time of the bid opening, and it was known then? Or when
At any time before there's a formal award, if there would have been this discovering that there was this misunderstanding, then the agency would have needed to have dealt with it. And this is what you would have done. You would have, first of all, if they'd have gotten the, if they would have said, let's say the vendor was a lot lower than anybody else. And the agency, when there's a big price disparity, typically is supposed to go back and verify with the vendor that it confirms his bid, i.e. didn't make a mistake. And so, for instance, and this might be a telephone call, or it might be at the bid opening and you say to the vendor, okay, stay afterward and we'll just talk a little bit since you're the apparent low bidder. And then just something as simple, okay, gee, I'm kind of surprised you won this time. That's a pretty good price for a 2-year period. And if the vendor would have said right then, what do you mean 2-year period? Right then, you'd have known you had a problem. So, and the issue is, what do you do? Anytime there is the allegation or the suspicion there's a mistake, your choices are, if it's obvious there was a mistake and it's obvious what the price should have been, you change the price. If it's obvious there was a mistake, but it's not obvious what the price is, the vendor is allowed to withdraw its bid, but what it cannot do under any circumstance is change its bid price.
Hit it, put in a claim under your rules of hidden versus obvious. Wouldn't it been turned out to be hidden and you'd won to get out of the contract?
Let's see. On page 3, it says this is a 2-year contract to start on X date and end 2 years later. I'm not quite sure what's hidden on the fact it's a 2-year contract. You're saying it's 12 o'clock. So you want me to finish this so people can go to lunch. All right, let's see. To avoid potentially being in a state of continual contentiousness with this vendor because of the 100% difference between what it thought it was bidding versus what it would be paid, or even if the situation was discovered before an award, the agency could decide the price is too good to pass up. So that's one thing. You can decide, I'm going to take the price and fight with the vendor, or, all right, or you could have decided that it's not worth fighting the vendor, and even though it's very iffy whether it's obvious there's a mistake, if the AG will agree to it, we can allow them to withdraw. So in this particular instance, they made the vendor perform for the price for 2 years. So if there's any questions, when we get to the second one after lunch, we can revisit that. But at this time, why don't you go and come back at 1 o'clock.